Yes, Mr. Chairman.
My Lord, before the short adjournment, my Lord Reid put to me the point about purpose and the case of Dodov. My Lord, it is an important point. I haven't been able to take full instructions on that over the lunch period, and I don't think I would have time to develop it orally in any event. My Lord, what I'd seek is permission to put in a short note dealing with that point after the hearing, say within 7 days, if that would suit the court.
Yes, we share it with the other parties taking part in the hearing, and if they've got any comments, then they can submit those also within, say, another 7 days.
I'm grateful, my Lord. If I can finish the point I was developing before the short adjournment about the acid test versus the multifactorial test. The charities and the official solicitor say that the acid test was not establishing any new principle of convention law, and it just simply applied HL. We say that is wrong, and I've shown the court the cases that we rely on for that. What the majority in Cheshire West did was to isolate a particular subset of factors and elevate those to a universal test for the living arrangements of those who are incapacitated. We say the majority in Cheshire West cited Ghazadi, but they did not apply it. And if I can give the court references to two cases post-Cheshire West from Strasbourg that confirm that the Strasbourg case remains the same. The first is that of Stankov and Bulgaria, which is in the bundle at 5187. I'm not going to turn it up, I'm just giving the court the references. The relevant paragraphs are at 87 and 88 at 5206. The court refers to constant supervision and not free to leave. But in exactly the same way as Stanev does, they go on to look at the duration and effect of the restrictions on the individual. That's also part of the objective limb because the subjective limb starts in the following paragraph at 89. The second case is one that we have not turned up, and that is Kaganovsky and Ukraine, which is from September 2022. We deal with that in our written case at paragraph 48, page 113. The page reference in the bundle is 5636. And it's an interesting case because it looks at two different parts of the same social care institution. One part which was found not to confine the individual, and one part which was found to confine him. And the paragraphs I'd like the court to read, if I could ask for that, paragraph 77 through to 84. And again, we make the point there is no sign of an acid test in any way. The court has identified the relevant factors, they look at the concrete situation, and they rely there on the fact that the individual was not free to leave in the restrictive unit, and his contact with the outside world was seriously restricted.
Do you have the page number of those paragraphs?
My Lord, yes. It starts at Article 5, the treatment of Article 5 starts at 5649.
Thank you.
And the paragraph of your written case that refers to it?
That is paragraph 48, page 113. And my Lord, we are not saying that this is a change in approach from the Grand Chamber's approach in Stanev, but it does confirm that that remains the Strasbourg Court's position. My Lord, we also don't have time to turn these up, but to refer in the domestic context to the problems that the acid test has created when the English and Welsh courts have tried faithfully to apply the acid test. And what we would say are the rather absurd consequences that the acid test produces. These are dealt with in AB, the case of AB, which is in the bundle at 3426, and the relevant paragraphs are paragraphs 10 to 13 at page 3429. And the second case is that of the London Borough of Havering against AEL, which is in the bundle at page 3481. And I'd invite the court to look at paragraphs 21 to 22, 28 to 29, and the conclusion at 46 to 47. And what we say these cases show is that because they are applying the acid test, The courts do not look, because they cannot look, at the duration or effect or manner of the implementation of the restrictions in question. Any sort of control is assumed to satisfy the acid test, despite the extensive freedoms that both individuals had and the ability they had to make choices in their lives. Now, my Lord, the second heading in my list of why Cheshire West was wrong is the absence of any reference to coercion, the lack of objections, and the failure to consider the effect of the arrangements. And we know that the fact that an individual is objecting to the restrictions is a relevant factor in determining whether the person is confined. And my Lady Simler yesterday referred to paragraph 73 of Stork at page 4660, which confirms that that aspect was treated as part of the objective limb of the analysis.
But isn't it more the place where they're living, reaction to them escaping? That the point is that somebody can appear to be compliant, but you only know that they're not forbidden to leave when they try to leave. So them trying to leave and be brought back is evidence of the constraint that they're under. Is that why it's being used there, rather than to show lack of happiness particularly?
Well, my Lady, I think it's both. It shows that there is the restriction, it shows how extensive the restriction is, because they cannot leave that particular place. But if they never try to leave the particular place because they don't want to leave the particular place, then there is no restriction that's being put in place. There is nothing.
That's the difficulty of ascertaining why it is they're not trying to leave. Is it because they're happy there, or is it because they know that they'll be brought back?
Well, my Lady, that may be part of the analysis, and that may be part of what the court has to look at. But what we say is that if you've got an individual who wants to leave the place that they live in, and they can't leave the place that they live in because either the door is locked or because they've got 3-to-1 carers with them at all times who will restrain them if they try to pass the door, or because if they do succeed in escaping, someone will go after them, locate them, and bring them back. That is, we say, very clear evidence that the individual is being confined. But we say, as a matter of logic and as a matter of principle, it must work the other way as well.
But not in every case.
Not in every case. It depends if the individual is capable of objecting. Now, if they are not capable of objecting, we know, for example, from HL, that mere compliance or acquiescence is not a relevant factor. But if they are capable of objecting, and they do not, then we say that is equally clear evidence that there is no confinement.
But again, that will depend on the facts. It won't always be, as my Lady Rose said. There may be cases where the individual knows that they'll be restrained, so there's no point trying to leave.
Yes. Yes, it will all depend, and it is capable, we say, of being looked at through an objective filter, if one can put it that way, because one looks at what is the individual doing. It's not a subjective state of mind, it's still objective. Did the individual take the step of trying to leave? Has the individual asked to leave? Are they indicating by their behaviour that they wish to leave?
Well, such as what?
Well, my Lady, there can be the sort of challenging behaviour in terms of physical outbursts that need to be restrained. There can be the situation, say in the Neary and Hillingdon case, where Stephen Neary wasn't capable of articulating that he wanted to leave, but his repeated attempts to escape from the building were, again, the clearest possible indication that he did want to...
What we're talking about is assessing the ambiguity of somebody not constantly trying to run out or constantly fighting to leave. How do you resolve the ambiguity of whether they doing that because they're happy or doing that because they know there's no point?
They know it's pointless. Well, my lady, that would depend on an examination of all the circumstances. As you say, if you've got the scenario that your ladyship put to me of someone who had tried once to leave, was then caught by police, brought back and shackled to the bed, one might well say, well, the fact that they're not trying to leave again doesn't actually tell us anything. But if you've got an individual, again, like Mig, very happy where she is, wants to stay where she is, the fact that she is not leaving and has made no attempt to leave is, we say, a relevant factor that goes into objective confinement. So, my lord, we say that the necessary element of coercion is missing if the person is not objecting to the arrangements. And we've set out in paragraph 44 of our written case, page 110, the cases we rely on in respect of coercion. We say that one has to consider the effect and manner of implementation of the restrictions, and I took the court to the cases on effect and manner before the short adjournment. We see Strasbourg dealing with that under the objective limb. If the Strasbourg court is considering the adverse effect of the measures on an individual, they must also consider the positive aspect, or the positive effect of the measures on an individual. The third aspect we rely on is that measures depriving a person of their liberty inevitably involve an element of suffering or humiliation.
Sorry, I didn't hear.
That any measure depriving a person of their liberty will inevitably involve an element of suffering and humiliation. And we deal with those cases in paragraph 45.2 of our written case at page 111 of the hearing bundle. And my learned friend showed the court Runem and Belgium yesterday. I'm not going to turn that up again, but that is probably the high water mark of that line of authority. There may be some philosophical debate about whether one has to have a degree of awareness to know that one is suffering or being humiliated, but we would say a person can be suffering even if they don't have the awareness that there is the possibility of anything better, because they don't know there are alternatives. And this would address the situation that Lady Hale referred to in paragraph 35 of Cheshire West, of an incapacitated person being forced by their family to live underneath the stairs. They may not know there is any alternative way to live, but nevertheless, the state of affairs, the objective restrictions imposed on them would still make that an obvious confinement. My lord, we do say it's important to look at some of the evidence that was presented to the Joint Committee on Human Rights when they examined deprivation of liberty. I don't have time to turn it up, but I would invite the court to read the evidence of Caroline Dockin about her daughter Eleanor. That is in the hearing bundle at 7183. 7183, my lord. And the oral evidence given by Mark Neary about his son Stephen that my learned friend took the court to yesterday at page 7200.
7200. Thank you.
So, my lord, we say the fact that a person is not objecting is one of the whole range of factors that the court takes into account in deciding whether there is confinement. And on this, we say that Lord Justice Wilson, as he then was right in the Court of Appeal in the Surrey case at paragraph 25 to 26, and that's page 2854. We say that taking account of these factors in Lim A accords with the Strasbourg case law, and it also results in what we say is a scenario that is beneficial in policy terms. And the reason is this. It's that if the acid test remains and the Attorney General for Northern Ireland is right on valid consent, then any expression of valid consent by the incapacitated person will automatically mean that the person is not deprived of liberty at all. It will simply take them out of that definition, no questions asked. But under our analysis, if we look at these factors under Lim A, if these are relevant factors in considering whether the Lim A test is satisfied, it is simply one of a wide range of relevant factors that the court will consider in determining whether the individual is confined. So you could still have extensive restrictions that have been put in place on the individual that might involve restraint, they might involve medication, they might involve social isolation. The person might say, I don't object to it. They might never try to leave. They might say they are content with the living arrangements, possibly because they know no different. But if the court takes into account all the relevant factors, as it must do under Lim A, they could still conclude that that individual was confined. If you only take these matters into account under Lim B, then it will automatically follow they're not deprived of liberty, regardless of the state of the restriction.
If you follow that and you say you automatically take into account all these factors in Lim A, you decide that they are confined, are you then saying that that would be a deprivation of liberty even if they appeared to be consenting?
No, because if there is valid consent, then it's not a deprivation of liberty.
So I don't understand what your point is, what the benefit of including consent type subjective points in Lim A is, unless you're saying that actually consent under Lim B is just one factor among many in determining whether they've actually been deprived of their liberty.
Well, Ed, if I could try putting it a different way, what we say is if you're with us on Lim A and you accept that valid consent means only consent that a person who has capacity to give it under the Mental Capacity Act, so it's tied to the domestic law concept. So if you're with us and not with the Attorney General, then we say you're taking into account those you're taking into account the lack of objection, you're taking into account the lack of coercion, you're taking into account the effect of the measure on the individual, and it is one of a range of factors that you take into account under Lim A.
So I'm so sorry to interrupt, but are you positively saying Lim B consent is the equivalent of capacity to consent, and if you haven't got domestic law capacity to consent, you can't consent under Lim B?
Well, my lady, our fallback position is if you're against us...
Is that your first argument?
Yes, our first argument is that these factors are properly considered under Lim A and not under Lim B.
So Lim B is irrelevant, or...?
Well, Lim B matters.
But what is Lim B? Is it still a de facto consent even if you've got no capacity?
Well, it's as we put in our written case, it's difficult. There may be some difficulties if an individual has already been determined to lack capacity to, under the terms of the Mental Capacity Act, applying that test to decide where they live and to decide on the care and treatment they receive. It may be difficult to see that there is still nevertheless some scope for de facto understanding.
So
with that
you do
determination.
seem to be equating Lim B with the domestic law concept of capacity then on that.
Well, my Lord, I wouldn't quite go that far. I'd say we can see some difficulties with it, and we've set those out in our written case. That's why we say it is preferable to deal with these matters under Lim A, and we say that's how Strasbourg...
But I mean, if someone doesn't have domestic capacity, they can't think things through rationally and retain the process of thought afterwards to make a determination. That is one thing. The de facto contentment, as it were, or consent that Strasbourg's speaking about as an autonomous concept is something less than that. It is that you are seen to be and are expressing a willingness to continue in the circumstances that you're in.
My Lord,
the domestic test doesn't occupy the whole territory.
No, it certainly doesn't occupy the whole territory. And that's why we have addressed in the case that there will need to be a clear... If the court does adopt the Attorney General's position on Lim B, there will need to be a clear distinction drawn between a decision about lack of capacity on the relevant matters under Section 2 and 3 of the Mental Capacity Act and what is meant by... where is that sort of alternative space for de facto understanding of the situation in circumstances where the court has determined you do not have capacity to...
Right, but doesn't the law just drive us there? because we know from section 306 of the Act, we've got to apply the Article 5 test of whether there's deprivation of liberty. And if that's different from the test for capacity under the Mental Capacity Act, well, then there are two different tests being applied.
So be it, absolutely.
Right.
But for guidance for decision makers on the ground, there is clearly scope for some confusion for the difference between a determination that the individual does not have capacity to decide where they live and the care and treatment they receive, and the concept of valid consent under Strasbourg case law. And we would say that if the court is to adopt the attorney's submissions on Limb B, that any helpful guidance the court can give about the distinctions between the two will be crucial, because the Secretary of State certainly does not want to see any dilution in the Mental Capacity Act test, which applies when decisions are being taken in respect of the person.
But if we were with the Attorney General and saying that there is an autonomous concept of consent under Limb B, and you have to look at the attitude expressed by the person, where then does that leave your submissions on Limb A? Are you saying that it's all in both A and B, or if we were with the Attorney General on Limb B, does that then obviate the need for any amendment of any revision of what the court said in Cheshire West on Limb A?
My lady, we would say they can be factors in both A and B. That's how Strasbourg treats them. And we say it is important that we get the Limb A definition correct, tied to the Strasbourg jurisprudence, so that we have clarity about how decision makers are to make these decisions on a day-to-day basis. Simply because someone may have valid consent or not be able to give valid consent doesn't mean that these factors don't go into... It's not exactly the same concept that we're talking about. We're talking about a lack of objection. We're talking about the effect on the individual of the restrictions. That's not the same thing as valid consent and having de facto understanding of the situation. So we say there's a world in which both of us can succeed in our arguments, that Cheshire West is wrong on Limb A, and that valid consent means what the Attorney General says it means.
Well, is there any difference between what you do and if you're looking at consent in accordance with an autonomous Strasbourg concept, and it applies to both Limb A and to B, how does that operate?
Well, my lord, we wouldn't say that consent applies to Limb A. What we say is a relevant factor under Limb A is the objective fact that an individual is not objecting to the arrangements, that there is a lack of coercion, that the individual is not expressing a desire to leave or trying to leave. So we're not saying it's the same thing, but it goes into the different limbs. It is different factors. They are factors that the attorney relies on to say that's why he's right on valid consent. But they are also factors we say that the Strasbourg court looks at under Limb A in determining whether an individual is confined in the first place.
And those are subjective factors in the sense that they are within the perception of P. They're something different from whether P is consenting or not, but they are that they're not coerced and they don't seem to be suffering and being humiliated, and they seem to be perfectly happy with where they are. As factors relevant to the question of confinement, overlapping in practice, but in theory at least distinct from whether they are consenting to such restrictions that there are. Is that?
Yes, although, my lady, I wouldn't describe them as subjective elements. So as I've described them, they are objective facts. Has the individual made an attempt to leave? Has the individual stated they want to leave? Are they demonstrating the behaviour from which one can infer, when one knows them well, that that's showing that's what they want to do?
But aren't those objective facts really only relevant because they demonstrate the subjective attitude of the individual? They keep trying to go out the door. I mean, in a sense, it's an objective fact, but why do we give its significance. It's because they're indicating that they're not happy where they are and they want to leave.
Well, my lord, that's precisely why they are important, because if you
Yeah,
show...
that's what I'm putting
yes.
to you. In other words, it's the subjective dimension of them that makes them important.
Yes.
It doesn't help, well, arguably, it doesn't help describing them as objective facts. It's what one draws from that.
Yeah.
But what one draws from those things is something which is demonstrative of the subjective attitude of the individual, isn't it?
Well, my lord, we say not. We do say that goes to confinement, because you're looking at...
Yes.
Well, it may go to confinement, but it may be that one's operating with sort of two rigid categories here, that looking at Stork, paragraph 73 and 74, maybe in what you've been calling the objective side of the equation, there are a range of subjective matters which come into play there. And in paragraph 74, the court identifies, if you like, a particularly intensive or especially significant form of subjective attitude on the part of an individual, which goes so far as to indicate valid consent, to use that term.
Yes.
So maybe what we've been calling the objective limb is really Ghazali, which is highly factorial and didn't use this distinction, and where there are subjective elements that come into that as well. And that paragraph 74 of Stork is sort of isolating out a subset of what could be regarded as subjective aspects of the attitude of the individual to their situation. Does it work in that way?
My lord, I'd accept that, yes.
Okay, all right, thank you.
I still have some difficulty in understanding your submission about, for instance, whether a person attempts to flee is evidence of their subjective intention, desire, refusal to accept the placement. And yet, that's considered in the objective element. For instance, at page 4660, paragraph 73, in the objective element, the applicant had attempted to flee.
Yes.
And she's once when she succeeded in escaping. So both of those are the subjective element of lack of consent.
Well, my lord, that's not how Strasbourg treats them, because these elements in paragraph 73 of Stork are all about the objective limb.
Is an attempt to flee an indication that somebody does not consent to being there?
Oh, my lord, it could also be an indication, because the ways in which one demonstrates subjective or valid consent for the purposes of limb B, it can be, one can state it if the individual is capable of stating it. I don't want to be here. Please release me from this. Or many individuals may not be able to articulate that expression of will, and one infers it from behaviour. So the behaviour in question there is repeated attempts to flee. But that's the difficulty with the way Strasbourg tries to divide up objective and subjective, and the way Strasbourg separates out the factors. What the case law shows is that the Ghazali elements go to the objective limb, and then in Stork they develop the lack of valid consent aspect as well in paragraph 74. But we see from the cases that follow Stork that factors can play in both limbs of the analysis.
You mean the same evidence can be relevant?
Yes.
So trying to flee can be relevant as then it becomes apparent what restrictions there are on the person. And it may also manifest their lack of consent.
Yeah. It would be hard to infer from an individual who has made repeated escape attempts from the institution that they are consenting, they are providing consent to remain there. So that one can see how it plays in that analysis. But it also goes to, as we say, whether we see Strasbourg treating it as going to whether they're confined in the first place. So turning then to the third heading, which was context, and the different settings in which an individual may be confined. All cases that have reached Strasbourg have been concerned with either, or for incapacitated individuals anyway, have been concerned either with psychiatric hospitals or large, remote, former Soviet-era social care institutions. So Strasbourg has never found that an individual living in their own home in the community, whether with their family or on their own, is a deprivation of liberty. We say the acid test draws no distinction between the position of individuals in a high-security psychiatric hospital and a person living in their family home, and that is a particularly problematic aspect of it. And the reason for that is that the effect of the restrictions on an individual living in their family home with their family or living in their own home are likely to be very different to the effects on an individual in a psychiatric hospital or the type of social care institution that Strasbourg has dealt with. And I've already referred to the restrictions and the effect of the restrictions on MIG in particular, and we've seen the discussion of that in Cheshire West, which I'm not going to repeat. But essentially what we do submit is that there is a need for far more extensive restrictions before something becomes a confinement if an individual is living in a family or ordinary home in the community. And I don't say these factors would all need to be present, but simply as examples, one would expect to see things like restraint or medication, seclusion, social isolation, things of that nature. And we say that the acid test simply ignores these different contexts, which would be important, we say, for Strasbourg. And then the fourth heading as to why we say Cheshire West is wrong is the liberty and autonomy aspect. We say that the acid test is highly problematic as it takes no account of any innate limitations to which an individual may be subject. And my Lord Hodge asked yesterday, were there any Strasbourg cases where an individual was found to be deprived of liberty where they were unconscious, where they were in a PVS or a minimally conscious state, for example? And the answer to that is no. We have seen some cases in the domestic courts, which I'm going to take the courts to in a moment, of an individual unconscious in intensive care and an individual in a minimally conscious state. We say the same kind of analysis would apply to individuals such as those at the end stage of dementia. I think it's Professor Eldergill who points out an individual who can't even conceive of being able to swallow, let alone able to leave the institution where they live. And it is absurd to suggest that the state is somehow confining this individual when they are simply innately unable to exercise any ability to leave or anything of that nature. And we see the case law in this regard starts with Ferreira, which was where, shortly after Cheshire West, the argument was raised that an individual had died in state detention, and so the coroner was required to summon a jury for the coroner's inquest, because they had been deprived of liberty when they were unconscious and sedated in an intensive care unit in a hospital. And that was how the matter came before the courts. And we see the judgment at 3189.
Page?
3189, my lord. And my lord, this was a case where, because we'd had a judgment at first instance, the Secretary of State was able to apply to intervene in the appellate level, and the Secretary of State did so. But of course, what we could not argue for the Secretary of State in Ferreira is that Cheshire West was wrong. We could not argue that. So we had to find a way of distinguishing Cheshire West so that what we say obviously sensible result could be reached, that an individual who's unconscious in an intensive care unit is not deprived of their liberty. And we see that, we see the Court of Appeals analysis that starts at paragraph 88, page 3213. So we see first Lady Justice Arden explaining that by analogy with Austin and UK, this was treatment in an intensive care unit is a commonly occurring restriction on movement, and we see that in paragraph 89. That was our first attempt to distinguish Cheshire West. We then see at paragraph 91, Lady Justice Arden confirming that you could distinguish Cheshire West on that basis. We then see paragraph 93, the lack of the policy need to apply the acid test. So that's Lady Hale's paragraph 57 and the need for periodic checks on living arrangements. And that's the Court of Appeal saying, well, that policy reason doesn't apply to someone in intensive care. So another reason to distinguish Cheshire West. And then we see paragraphs 96 through to 99, which we say are crucial. First, the court accepting the argument that the hospital would not have prevented or did not prevent Maria from leaving. So even if Cheshire West applied, it didn't. The free to leave limb of it was not was not in play. Was not satisfied. And then the paragraphs we rely on, which were part of the submissions that we made to the Court of Appeal, is 98 and 99. The two-part acid test formulated by Baroness Hale was designed to apply only where the second element, lack of freedom to leave, was the consequence of state action, particularly state action consisting of the continuous supervision and control constituting the first element of the test. So the Court of Appeal is here recognising that in the case of a patient in intensive care, the true cause of their not being free to leave is the underlying illness, which was the reason they were taken into intensive care in the first place. So that there was an argument that actually the state was doing something in terms of sedating them. So here Lady Justice Arden's dealing with the sedation aspect. The person may have been rendered unresponsive by reason of treatment they've received, such as sedation, but while that treatment is an immediate cause, it is not the real cause. The real cause is their illness, a matter for which the state is not responsible. So it is quite different in the case of living arrangements for persons of unsound mind, etc. But we say that key aspect, the first half of paragraph 99, does apply equally to independent living arrangements. And the only reason why Lady Justice Arden had to distinguish it in this case was the obvious reason that the court was bound by Cheshire West. But we say the logic of the conclusion in paragraph 98 and 99 applies not only in the intensive care setting in a hospital, but applies equally to those in an independent living situation.
Then, if you've got someone with mental capacity, and it's been with lack of mental capacity, and it's been determined that it's in their best interest to be confined, then how could they ever be deprived of their liberty, even if they were strongly objecting? Because you would say it's because of their lack of mental capacity, and it's been determined it's in their best interest. So it's their mental incapacity that's the cause of them being confined, not anything that we're doing.
Well, my lady, first of all, we do not go that far. We're certainly not saying that anyone who lacks mental capacity to decide where they live and the care and treatment they receive would fall within this principle.
No, I'm talking about someone for whom it has been determined that it's in their best interest to do this.
Well, whether it's in their best interest or not, we say doesn't really matter in terms of the deprivation, whether the question of whether they are deprived of liberty in the first place. It doesn't matter at all. What we're saying is, if you have got an individual who is so physically or mentally unwell, profoundly physically and mentally disabled, as the cases have gone on to look at, and the reason why they cannot leave is not because of anything the state has done to them or the state has failed to do for them in the exercise of positive obligations, but because of their innate condition. So the person who's in intensive care in a hospital, the person who's in a permanent vegetative state or minimally conscious state, the person who is at the end of life stage of dementia and is completely bedridden, can't do anything at all, or the person with the kind of profound and multiple difficulties that the child in SM has, which I'll take the court to in a moment, then one has to stand back from this and say, well, what is the state doing in that situation that could amount to a confinement? And the answer is nothing.
All right, but you're
because
not,
the
you're
reason
not then saying the reason why we have to lock the doors and stop them going out is because of their mental incapacity, and therefore it's nothing that the state is doing, it's because of their illness. No.
No, completely not, my lady. It is very much confined to those kind of situations where the state is not doing anything at all. And it is the individual's innate limitations that mean they cannot leave.
Well, another way of looking at it is they're not deprived of their liberty.
Well, quite, my lord, because they never had it in the first place.
You don't have to go on, as far as I'm concerned, to say you're not deprived of your liberty by the state, because you're just not deprived of your liberty. Your liberty has been deprived, unfortunately, by the medical and physical condition. But you have to distinguish between that type of case and a person who is able to form an intention to leave. And in those circumstances, consent then depends upon an understanding, having a sufficient understanding. And if the person hasn't got a sufficient understanding, then there is no question of consent.
Yes, absolutely, my lord. Yeah. We would agree with that. And so we do say Ferreira is a wider application than simply in intensive care in a hospital. It has been given wider application by the Court of Appeal in the case of Briggs, which is at 3221, where the Court of Appeal confirmed that an individual in a minimally conscious state was not being confined. And we see that at paragraph 105 of the judgment, which I've lost the page reference for. Do you have that?
What page?
Briggs is at 3221, and then paragraph 105 is at 3247, Ms. Gannon tells me. Yes, that's right. So this was a case, it followed, the first instance judgment had been before Ferreira, and then the appeal was after Ferreira. And the submission we made is, well, Ferreira determines this individual is not being deprived of liberty. There shouldn't be a standard authorisation at all. And we see at paragraph 105, the Court of Appeal is confirming that neither Ms Richards, on behalf of the applicant, nor counsel on behalf of the official solicitor were prepared to concede that in the light of Ferreira, in respect of which permission to appeal to the Supreme Court has now been refused, the judge had proceeded on mistaken premise at first instance, where the judge had proceeded on the basis there was a deprivation of liberty. And then the Court of Appeal says, for my part, I find it hard to see how an argument could now be framed to the effect that Mr Briggs was being deprived of his liberty during the months he was in hospital and being cared for in a minimally conscious state. That being so, no standard authorisation was necessary, etc. And then 106, Ferreira's case confirms what I myself would regard as an obvious point, namely that the question of deprivation of liberty does not arise where a person who lacks capacity is so unwell that they are at risk of dying if they were anywhere other than in hospital, and therefore, by virtue of their physical condition, they are unable to leave the hospital. So that was Mr Briggs's particular factual circumstances, but we say again it can go wider than that. And
and just for observation, in line with my Lord Stephen's point, this isn't tied to responsibility of the state. This is just a function of whether someone is suffering a deprivation of liberty or not.
yes. Yes.
I think one needs to be a little bit careful with responsibility of the state, because looking back at Stork, there was a separate issue about responsibility of the state, yes. And one wonders whether in Ferreira that might have been brought into the analysis of whether there's a deprivation in the first place.
Yes. And my lord, we see from when looking at that positive obligation aspect, we see that Mrs Justice Leven deals with that in the SM case, which is at page 3859 of the bundle. And we can see the background from the head note, but I don't have time to go through that. But the restrictions on the child's particular position is set out in paragraph 7 of the judgment at page 3861. And the arguments that were being advanced as to why the child was being deprived of liberty were firmly anchored in Cheshire West. We see at paragraph 26 the local authorities' submission as to why they said the child was deprived of liberty. Page 3868. And then if I can invite the court after today's hearing, to read between paragraphs 31 to 45 of Mrs. Justice Leaven's conclusions as to why the logical consequence of Cheshire West is that a child in SM's position is being confined by the state, and her reasoning as to why that cannot possibly be correct, given the nature and extent of the very profound limitations, the very profound disabilities that SM had in this particular context. We deal with that in our written case. We deal with that analysis. The approach of Mrs. Justice Leven has been the subject of extensive criticisms by other judges at a High Court level, but we say nevertheless SM is right. It follows from Ferreira. It follows from a proper analysis of what it is that is preventing the individual from being able to leave in this particular context. My Lord, if I had more time, I would spend more time on this, but I've only got 15 minutes left, so I do feel I have to move on. All I can do is ask the court to read the article from Professor Eldergill, which was written before SM, but supports very much the analysis that is in Mrs. Justice Leven's judgment. That is in paragraph 39 of our written case, and the article is found at page 6375 of the hearing bundle. So, my Lord, we say Cheshire West is wrong for all of those reasons. Heading 4 of my submissions is, should this court invoke the practice statement and depart from Cheshire West? We say yes. We've never shied away from that conclusion. It is the inevitable consequence of our submissions that Cheshire West is clearly wrong. The practice statement's in the bundle at 2516. My Lord Hodge, I think, raised some points with my learned friend yesterday about this. What are the conditions for departing? Middle paragraph, too rigid adherence to precedent may lead to injustice in a particular case and also unduly restrict the proper development of the law. We would say that is what is happening here. As we say, it's so wide, no individual can take a case to Strasbourg. No one can argue below because everyone is bound by Cheshire West. And indeed, we say that's why this court gave the guidance it did in AB, that domestic courts must not take the protection of convention rights further than they can be fully confident that Strasbourg will go, just so that we do not end up in this situation where no one can ever get this issue tested by Strasbourg. In terms of the last paragraph, there have been no disturbing impacts on commercial transactions or contracts, settlements of property, etc. All that will happen if this court does overturn and depart from Cheshire West is that many individuals have been subject to intrusive assessments that they did not in law need, but there is no harm to anyone as a result of that. It will simply mean that going forward, we return to the position we say we should always have been in to start with.
And you say there are adequate mechanisms by which someone can raise with the Court of Protection or the supervising body a concern that actually they are being deprived of their liberty, or even though the place where they're living says they're not.
Yes. My lady, that's exactly our point, yes.
There will also, though, be difficulties in applying the multifactorial Strasbourg test. I mean, one of the advantages of Lady Hale's test was it was an acid test. Now, the disadvantage is it is brought within the ambit of deprivation of liberty. Most people would have thought, and certainly I at the time thought should not. But the disadvantage will be that people making the assessment will have a multifactorial test to apply. Would there be any intention to provide a code of practice or guidance to people as to how they go about this? Because it strikes me as being quite difficult.
My Lord, that would certainly be the government's intention. with all the discussion about statutory definitions of deprivation of liberty, where that ended up was the statutory definition was withdrawn and the government gave an assurance that they would provide further guidance on the meaning of deprivation of liberty in a code of practice. The government has prepared a very detailed draft code, consulted on a draft code of practice, an updated draft code of practice for the Mental Capacity Act, which includes a very detailed chapter on deprivation of liberty. That went out for consultation. Obviously, that will need to be revisited in light of the judgment of this court, but it is certainly the government's intention that further guidance would be provided in a code of practice. The Secretary of State announced shortly before the hearing that he does currently intend to bring into force the liberty protection safeguards and will consult on those safeguards in the first 6 months, or consult on how and when to bring them into force in the first 6 months of 2026.
Because the people making these assessments won't be lawyers, and certainly won't be lawyers
Exactly.
necessarily expert in this area.
Quite. But part of that consultation, part of bringing the LPS into force, will involve updated guidance, probably in the form of a code of practice.
Yes.
that will be produced.
But if this court were to hold that the idea of formal consent was, or indication of willingness to stay, or whatever you call it, what was an autonomous concept, you'd have to separate that out, presumably, from MCA guidance.
Well, my lord, the concept of valid consent would only apply in the situation of deprivation of liberty that we're talking about.
Yes, but if people are having to make a decision whether someone has been deprived of liberty in the Strasbourg sense, then they would have to address that.
Yes, and any new code would
That code would have to address it, because your primary position this morning was that the MCA test and the valid consent test was the same thing. Or have I misunderstood you?
Well, my lord, we say that it would be very important to make clear the distinction.
Well, that's my point.
If
If this court were to conclude that there was a distinction.
Yes. Because, my lord, as I'll come to in a moment, but our fallback position, as the court knows, is that if you are against us on Lim A, if the court decides not to depart from Cheshire West, then we do adopt the Attorney General's submissions, because somehow, at some point in determining what is a deprivation of liberty, the court and those applying the test must take account of the wishes and feelings of those who are subjected to the confinement.
But there's a middle path, as we've discussed, where some apparently subjective elements, like the effects of the restriction and the measures, may go into Lim A, but nonetheless consent is separate and is in Lim B.
Yes. My lady, that's right. But what we would not want to do is to leave this court and to leave Cheshire West as it is, with no means of taking into account the wishes and feelings of the individual. So if it's not in Lim A, it needs to be in Lim B, and if you're against me on Lim A, we do adopt what the Attorney General has said, subject to the caveats that we have set out in our written case about the need for that clarity between what is MCA capacity and what is valid consent, the need for clarity that this concept of valid consent only applies when assessing what is a deprivation of liberty. So it's not some watering down of capacity in, say, consenting to medical treatment, for example, and the need for further and additional safeguards about how one, or further guidance to those on the ground about how one ensures that those wishes and feelings, that consent, is genuine.
Yes, because consent is a concept that's used all across the law. But here, what we're talking about is consent for the purposes of the definition of the deprivation of liberty in Article 5.
Yes, and that we say is very important, because the watering down of the Mental Capacity Act test in other contexts would have very serious consequences,
Yes, of course.
particularly in relation to medical treatment, for example.
But you're also not saying that if we're with the Attorney General on a different definition of consent, then you're happy with that, we can leave Lim A alone. You're not saying that.
No, my lady, we're not saying that. We're saying Lim A is so clearly wrong, it's so contrary to the Strasbourg jurisprudence that it does need to be addressed by this court and it does need to be departed from. Well, Lord, I've taken that somewhat slightly out of order and then I've dealt with my sixth heading before I finish with 4 and 5, but I'll try and finish 4 and 5 very briefly. In terms of the invoking the practice statement, my Lord Reid referred to ex parte Hudson yesterday, which we would agree with what your Lordship said, what your Lordship suggested there, that there is a scenario for departing from a question of statutory construction if it were convincingly shown that a previous construction, clearly demonstrated to be wrong, was causing administrative difficulties or individual injustice. My Lord, we've looked at the statistics, we've looked at the significant and unanticipated impact of Cheshire West, we've looked at the resource implications, £2.2 billion per year to administer the deprivation of liberty, safeguards, etc. And we do say that that is more than sufficient to satisfy the Hudson test. But more than that, we say, as the Joint Committee on Human Rights pointed out, that there is a danger that a scheme that applies too widely will be so light touch as to reduce the protection for those who truly need it. So in the midst of those almost 400,000 people who are currently treated as being deprived of liberty, the risk that those who are really deprived of liberty, as Strasbourg would see it, who really need the protections of Article 5, risk being lost amongst the 400,000 people or the 400,000 applications that are being addressed. My Lord, in terms of Dalton, we've dealt with Dalton in our written case, paragraph 58 to 67, here in bundle 117. Those set out the 7 reasons why we say this court should depart from Cheshire West. I don't have time to go through those now, but I would ask the court to read those paragraphs carefully. And my 5th heading was simply to respond very briefly to certain points made by the charity and the official solicitor.
That's your 5th heading.
My 5th heading. I've already dealt with 6. I've taken them slightly out of order in response to questions. So we've dealt with their criticisms that the reference doesn't concern the objective limb of stalk, so you don't need to determine it. And we also explained why the Secretary of State has not been able to raise these issues in a concrete case before the Court of Protection. The next criticism made by the charities is that the point I think that my Lord Hodge put to me, that whatever may be wrong with Cheshire West, it did at least have the advantage of setting out a clear test, which is easy to apply. We do take issue with whether the test does provide certainty for those applying the test on the ground. We've outlined the areas where there remains a considerable lack of clarity in the application of the acid test, particularly as the lower courts try to address the Ferreira and SM issue, and the difficulties the courts have had in determining what is actually meant by continuous supervision and control. How extensive does it have to be? We say it's inevitable there's going to be some uncertainty because that is the result of the Strasbourg test. That is the result of the Strasbourg jurisprudence. When the test is one based on degree and intensity, that is inevitably going to be the consequence. The Strasbourg courts recognise that there will be borderline cases, and they refer to cases that may be a matter of poor opinion, and that's the language of Strasbourg, but they emphasise that courts must ultimately make that selection. And we see that referred to in Ghazadi all the way through the case law. Ghazadi, Stan Everett 115, page 4908. The second point made is that unless you treat all these individuals as being deprived of liberty, there will be a gap in protection and there will be no periodic check on their living arrangements. And the contention, certainly from the charities, seems to be that unless all of these individuals are treated as being deprived of liberty, any poor care or issues around that will not be addressed, as there won't be any periodic check on the individual's arrangements. We've set out in the annex where these periodic checks come from. We've set out what the safeguards are in place, including by the use of independent advocates and IMCAs. And in any event, we say if there are any gaps in the domestic protective framework, then those gaps will be carefully considered by the Secretary of State and presumably by the Welsh Government, who are responsible for social care in Wales, and steps will be identified to fill those gaps. That is a policy choice for the respective governments, and it's wrong in principle to address any gap that may exist by extending deprivation of liberty. The third concern is how will one ensure that the wishes and feelings of these individuals are genuine and are not being misinterpreted or led by suggestion or coercion. We say we've already dealt with that in our annex as well, and I've outlined briefly on my feet the particular measures that are in place in England and Wales to ascertain what an individual's genuine wishes and feelings are, through the use of family members and friends who can know the person best, and if they're not available or not appropriate, through the use of IMCAs and independent advocates. So this is not a case where the local authority commissioner or the care provider, it is left entirely to them to determine what the wishes are, as the charities paint some kind of incentive to reduce the number of people who are deprived of liberty. It is not left to those individuals. There is a role, a statutory role, that we've set out in the annex to ensure
that in the best interest, for example, the best interests test, you take into account the wishes and feelings, so people must be used to working out what those are, and one can sort of repurpose that process for this.
Exactly, my lady. Purpose. Yes, that's exactly the point we make. My Lord, I think as I've dealt with point 6 in response to questions, I'm not going to go over that again, and that brings me in just 2 minutes over the 3 o'clock deadline. So unless the court has any questions, those are our submissions.
Thank you very much indeed, Ms. Clement.
My Lords, my Ladies, I appear on behalf of the 3 charities, Mind, MENCAP and the National Autistic Society, with Ms Kelly and Dr Lewis, who sits behind me. And the charities are also very grateful for having been given permission to intervene and both to file evidence and make these submissions. I'm going to deal with the Attorney General's proposal in relation to valid consent, and I expect that will probably take me the rest of today. Tomorrow morning, my hope is that Ms Kelly will briefly be able to address the court in relation to the standard of review and whether, in principle, the court should revisit Lim A, the decision in Cheshire West. The current plan is that I'll then make brief submissions in relation to whether Cheshire West is wrongly decided. It may be that we run out of time and that Ms Sutton, for the official solicitor, makes those submissions, as she and I think, will likely be saying many of the same things. The question raised by the reference is whether valid consent in the context of Article 5.1e requires a person to have mental capacity to consent to the arrangements for their care within the meaning of the relevant domestic legislation. And the charities submit that the answer to that question is a clear yes, and that to endorse the approach proposed on behalf of the Northern Irish Minister removes essential legal safeguards from disabled people and replaces them with a confused and unpredictable system in which inadequate, overly restrictive and even abusive care would go unchecked. It's in the nature... I beg your pardon?
Why do you refer to 5.1e? Surely it comes in from the earlier stage, namely whether or not a person is detained.
Yes, but in this context we're talking about the 5.1e aspect of Article 5.1. Yes, yes.
Okay, sorry.
It's in the nature of the reference that the court doesn't have any specific factual context, that you have no real-life examples of these hypothetical people who simultaneously lack capacity to consent to their care arrangements, but can nevertheless give valid consent to them for the purposes of Article 5. At most, what seems to be said is that perhaps Mig and maybe Meg might be illustrative examples. The charities have endeavoured to provide some of that critical factual context in relation to people with learning disabilities, autism and mental health problems. And my lords and my ladies will note that there is nothing in the charities' evidence to back up the assertion made on behalf of the Secretary of State that people and their families find these assessments intrusive. That is not the experience of the charities. You've been taken to the evidence of 2 individual families to support that assertion. It is not the charity's experience. We say that it is essential for this court to have an understanding of the sort of people who are directly affected by the issues that have been raised in the reference, That is, disabled people who cannot understand, retain, use or weigh information to make a decision about their care provision by reason of a mental impairment. And we say that there are three aspects of the broad factual context that the court needs to be aware of. The first, and most straightforwardly, is the sort of care with which people may be provided and the settings in which it may be provided, which could be care homes, supported living, or in their own private homes. And at page 136 of the hearing bundle, in the witness statement filed from the National Autistic Society, we set out the sort of interventions that may be imposed on a disabled person who doesn't have capacity to consent to them in their best interests, not just in a psychiatric hospital, but in their own home. And they include such things as sedating medication, relevant to the example my lords and my ladies have come back to of the person with advanced dementia. The overuse of antipsychotic medication for people with dementia is a well-known phenomenon. It includes the use of medication such as that which Meg was prescribed, risperidone, an antipsychotic medication designed to sedate her.
Could I have the page number again? I'm so sorry.
Yes, 136.
136.
It includes physical restraint by holding someone or by using equipment or devices. It includes solitary confinement, perhaps in a room of their own home that might have padded walls. It could include CCTV and electronic monitoring. There may be restrictions on contact with other people, members of their families and others, both online and in real life. And it may involve an inability to leave their home other than at designated times when sufficient numbers of support workers are available to accompany them. And those sorts of measures can be imposed at any time in their best interests. They don't wait for an annual care review to be considered. Whatever someone's care package today, and no matter how benevolent or benign it appears, it may not be the same tomorrow. And one can see that from Mr. HL.
When you use the phrase care package,
yes,
is that a term of art, or is that just a way of describing how...
It's a quick way of describing the care and support measures that are in place, so support workers, but also other elements of the care, such as the use of medication, restraint, and so on. Ms. Clement said, look at the effects on people and notice that as a matter of principle, the effects on people of their care arrangements are going to be different in their own homes than in institutions. And in my submission on behalf of the charities, need to be very careful about that submission. The official solicitor gives an example of a young man who lives in his own home, a normal bungalow on a normal street, but inside the bungalow, there's a perspex screen dividing him from his carers and he's fed through a hatch. Now, that is the sort of arrangement one might have thought would only appear in a psychiatric institution. But in the new world in which community care has been given effect, very restrictive arrangements do take place in what are normal homes. The second element of the factual context is the nature of the mental disabilities and impairments which may result in someone being judged to lack capacity to consent to their care arrangements. Those impairments can affect someone's ability to understand the pros and cons of their care arrangements and whether there are any alternatives. They can affect their ability to express a wish or a preference at all, and they can affect the extent to which any wish or preference can actually be elicited from their communication or from their behaviour. And the court has evidence, detailed evidence from the three charities on this. I don't have time to go to any of that in detail, but I'm just going to flag up the following from each of the three witness statements. In the evidence of the National Autistic Society, starting at page 137, noting that autistic people's wishes and feelings are at a very high risk of being misinterpreted or led by suggestion or coercion. And they give a specific example where an autistic person might laugh to indicate distress or pain.
So which paragraph?
So that's paragraph 36 on page 140. Apologies, there's going to be so many page references coming up, but I wasn't going to try and take you to them because there simply isn't time to do it.
So it's paragraph, yes, 30...
yes, sorry. So it's starting at page 137.
Yeah. And particularly you're now referring to 140.
Yes, and then 140, paragraph 36.
Yes.
Paragraph 37, the fact that people learn social scripts and say what they're expected to say. Paragraph 39, how difficult it is to interpret whether behaviour is serving a communicative function or not. Paragraph 40, the difficulty that autistic people can have in understanding and identifying their own emotional states, which means that they may report feelings which don't actually match what they're experiencing. Paragraph 41, that it may be difficult to decide a course of action or express a wish that's outside their immediate experience. And paragraph 42, that the value that autistic people may place on rigid routines means that a preference for routine can be misinterpreted as consent. The witness statement on behalf of Mind is based and informed by a brief period of consultation with independent mental capacity advocates who have reported examples of these issues in relation to how mental impairments affect the ability to ascertain people's wishes and feelings. Page 161, paragraph 29, one of the INCAs reports that some of our clients have cognitive impairments which are so significant they can't notice poor care, but there are also those who don't want to make a fuss. Page 163, paragraph 36, an example of an individual who'd been judged not to have capacity to make decisions about their care, but on review by the IMCA, it turned out that they did. Page 165, paragraph 43, people with these sorts of mental impairments are vulnerable to agreeing to suggestions based on how they're worded.
And how do these people get an IMCA?
So that is such a good question because my lady was taken very briefly earlier to the provisions about IMCAs. Unfortunately, because of the limited time, my lady didn't have a full picture of them. So IMCAs, under the relevant sections that my lady was taken to, are appointed in relation to care decisions, not medical treatment decisions. If there is a new plan to move someone into a different form of residential accommodation, or if there's a change to their residential accommodation, and if that residential accommodation is provided to them under the statutory provisions, and this is just in England and Wales. So there's no entitlement to an IMCA in relation to a change to your care arrangements. So if you're staying in the same house, but whereas yesterday you were allowed out and today you're not, that doesn't trigger an entitlement to an IMCA. If you yesterday weren't being prescribed antipsychotics, but today you are, that doesn't trigger an entitlement to an IMCA. And if you're a self-funder whose loving family have put you in a care home because they can no longer look after you because of your dementia, you have no entitlement at all because your provision is not being made pursuant to the statutory obligations of a local authority. So these examples have come about because for the past 11 years, IMCAs and what's called a relevant person's representative under the Schedule A provisions, and that can either be a family member or a paid advocate, such as an IMCA, have been able to go in, talk to the person, figure out what's happening and bring such challenges as they consider to be appropriate.
And that's because the person is deprived of their liberty.
Exactly. So going back to the statement, paragraph 44, the example is given where an individual appeared to be not just compliant but happy with their care arrangements, but it turned out on closer scrutiny that they were stockpiling medication to take an overdose. Paragraph 54, a man with paranoid schizophrenia who wanted to leave his care home unaccompanied but told his advocate he didn't want to be seen as problematic and so he couldn't raise that directly with the care staff. And at paragraph 55, a list of the factors that might explain why a person appears happy but isn't, including a lack of advocacy support, institutionalisation, coercion or intimidation by care staff or family, and past experiences of trauma. The one example I would like to take the report to is at page 182, and this is in the witness statement filed on behalf of MENCAP. apologies, page 181, case study A. And I would invite the court to think about Mr. A when contemplating the hypothetical examples that have been canvassed in discussion.
Sorry, page 180?
181.
81.
So Mr. A is 34, he lives
Yes.
in his own home.
Study A.
Yes, with 2-to-1 support at all times, and he has a severe learning disability and autism. He has locked doors, a locked garden gate, locked windows, locked internal doors. His movements inside the home are tracked using AI, and in the community, when he goes out, he's seated behind an acrylic screen running his car. He has limited ability to communicate. Paragraph 38. Unfortunately, Mr. A has had prior experiences of abuse, during which he was able to appear for some time to be happy and at ease with his surroundings. It was almost a year after his involvement in a known abuse scandal, once safe, that he began to reflect upon his experiences in the placement and to question whether the extreme abuse he received was right or wrong. How does that example tie into the person with very advanced dementia who can't form a view or a wish? Mr. A clearly can form views and wishes. They may be difficult to elicit, but what he didn't do while in a placement where he was being subjected to abuse, not just not very good care, abusive care, what he didn't do was indicate that at all, and he appeared to be happy and at ease with his surroundings. Now, it's very easy to say, well, of course, that's not the sort of person we're seeking to exclude or carve out, but why not? That's the challenge with all of this. It's very easy to come up with hypothetical examples or even the odd real example and say, well, that person doesn't need the safeguards. That person shouldn't be seen as being deprived of their liberty. But there has to be some proper, logically coherent, principled explanation about why that person falls on one side of the line and someone else doesn't. And so phrases such as not able even to form a view are rather difficult to apply in this sort of situation. And down at paragraph 41, it's explained that given A's past experiences, he can have low expectations about how he should be treated. And an example of that at paragraph 42, when he first came out of hospital, he would take himself to the floor because he was so used to being restrained. That was what he expected to happen if he was agitated.
Is your worry that he would be treated as consenting to the confinement?
Yes.
Right.
Yes, it is, because he was said to be happy and at ease with his surroundings.
I mean, why wouldn't that be a sort of matter of interpretation, taking account of all these circumstances? I mean, what you've set out here is a whole range of circumstances why one wouldn't actually have confidence that
Yes.
expressions of compliance by A are genuinely indicating sort of unconstrained consent
Well,
on his part.
the problem is one only has those beliefs that what he's saying might not be the whole picture once one is in the position we are now of knowing that what happened was that he was subject to abusive care that he couldn't report, didn't identify or recognise.
Right.
Yes, it's the ability of the person making the assessment to
Yes.
access information of this detail.
Yes.
Yes.
But would the person making the assessment, for example, of best interests and an expression of wishes and feelings, have this level of detail?
Well, it all rather depends, because on an annual Care Act assessment, for example, in England and Wales, the focus of that assessment is what are your needs and are they being adequately met? The focus, that assessment likely to be carried out by a social worker who may never have met you before. The assessment itself would obviously normally involve talking to family members if you happen to have any, or anything of that sort, speaking to the care provider themselves, who of course are not going to report abusive care. But there's not going to be that same level of scrutiny that you have with the deprivation of liberty process, where you have an advocate whose job it is to try and figure out what's actually going on and what the person's actual wishes and so on are. And it's just, is really evident from the charity's evidence, various of the reports from the independent monitoring organisations in the bundle, that what this DOLS process has done, yes, it's been an administrative burden, no one's going to pretend otherwise, but it has given people the ability to scrutinise and pick up on overly restrictive care and do something about it, other than by trying to bring an application for judicial review or similar.
But an advocate might be misled. I'm so sorry.
No, I was going
An advocate might be misled by these behaviours
Yes.
as well. I mean, at a certain point with any administrative
Yes.
system, you reach a limit to what can be achieved.
Of course, and there are always going to be things that go wrong in whatever system, no matter how good it is. That's obviously accepted. But what the court's being asked to do here is to say, carve out a category of people who lack capacity to make these decisions, but nevertheless can be seen to be giving valid consent. And the task that the court has been set is to figure out who those people are and how you identify them. And in my submission, it's not good enough to say, well, we'll worry about that in the code of practice, because as a matter of principle, there has to be some way of understanding what it is that is being said. And so what the court's been told so far to try and pin that down is, well, we're trying to exclude we're covering people who have a positive attitude towards their placement. That's what's said in the draft code of practice. Well, Mr. A had a positive attitude towards his placement. Then what's said as well, we're looking at people who you can either tell that they have a positive attitude by what they say, or you can infer it from their behaviour in some way. Again, we're going to see the difficulties in doing that. The difficulty in my submission is the step from there are some people who we can think of hypothetically who don't need these safeguards to, well, who actually are they and how do you explain how you spot them? So I'm going to come on to say why, in the charity submission, in any event, the Strasbourg case law actually demonstrates that the domestic approach to capacity to make decisions is actually the same as the substantive content of valid consent. But these examples just serve to illustrate how difficult it is and how careful the court needs to be in trying to rely, particularly on hypothetical examples, to try and carve up this group of people who lack capacity to consent to their care arrangements into subsets.
Right. I'm sure you'll come on to the Strasbourg authorities, but I mean, there are indications in the Strasbourg authorities that however difficult it may be, some sort of evaluative assessment is called for in terms of assessing whether there is consent or not. So looking at HL, for example, paragraph 90,
yes.
Compliance isn't enough. The fact the person had rendered themselves up for
yes.
treatment in a particular way wasn't enough. Why wasn't this enough? Because the court was prepared to look behind that and
yes.
make an assessment. Conversely, in the Mihailov's case, you get this idea of tacit consent to the second period of confinement.
Yes, I'm going to come to those, and I'm going to take the court to some additional authorities that the court hasn't been taken to yet, which I say explain what's going on.
All right, but really my question is,
yes.
Do you dispute that the Strasbourg court does seem to lay down this rather, well, it may be said to be difficult to apply criterion of valid consent, but the way in which they themselves seem to do that is by making some evaluative judgment, taking account of the overall situation of the individual to see whether you can rely on the consent, appearance of consent.
So we certainly accept that valid consent is a critical part of the three-part test. We say that it can be considered separately to the objective limit. It makes sense to do that. And we say that when you look at the case law in Strasbourg, you can see that what they mean by valid consent is not far off what we mean by capacity to consent to a particular set of care arrangements.
Thank you.
So just on the evidence, I think the last couple of bits just to flag up is the statement of mind at paragraph 163, and this is my third element of the factual context, and that is that dependence on other people to make care decisions and provide all of your vital care, including taking you to the toilet, giving you food and drink, giving you pain relief, every single aspect of your care means that this group of people are hugely vulnerable to harm. And at page 163, one of the IMCAs who responded to mine's call for information gave an example of the people that they had seen under standard authorisations under the DOLS regime And they say their view was that without advocacy, those individuals would likely experience neglect in care homes. They see neglect on a regular basis, which they flag as poor practice and report to the care homes, the CQC and the local authority. But if people were not subject to the standard authorisations, they would not have the benefit of a mental capacity advocate, and these instances of neglect would be unlikely to be reported or addressed. And at paragraph 38, just by way of example, the safeguarding alerts that this one advocate raised included a person not being able to reach their call bell, a person unable to access support, a person not being provided with a drink within reach on an extremely hot day, a person not being provided with appropriate personal care, which is the euphemism for cleaning and toileting, in a timely manner, and staff not administering medication as prescribed, and the resident becoming unwell as a result. Now, it's easy to distance ourselves from large-scale social care institutions in Eastern Europe and Russia, but these are fundamental, basic care needs which are not met for people in care homes and in other settings, notwithstanding the excellent legal frameworks that we have that you would think mean that this sort of thing didn't really happen. And this is the context that the charities provide their evidence in, is that they have seen in the 11 years since Cheshire West was decided these sorts of examples, and they have seen the benefits to people of being able to actually challenge them. And the one bit of the Care Act provisions that could have, to an extent, stepped in to this possible gap in the safeguards, which was the ability to challenge the content of your care arrangements at a tribunal, that's never been brought into force. And what's said now by the Secretary of State in relation to the objective limb is tantamount to saying that the more disabled you are, the fewer safeguards you have. Because if you're the person who can't walk, if you're Mr. A, and not only can you not identify that you're in an abusive care situation, but also you can't walk, so you couldn't leave even if you had spotted that, then you're now outside this whole territory of Article 5 because your innate disability means that you can't exercise the liberty that the rest of us have. And so, while, of course, on behalf of the charities, I would absolutely accept without hesitation that there are people who are caught by the current approach to Article 5 who, as a matter of fact, don't need those safeguards. They have excellent care arrangements, they have bespoke packages, they have 24-hour access to support staff so they can leave the house whenever they want to. They have no restraint, they have no chemical sedation today. There are any number of people who are not in that fortunate position, and all of these people are vulnerable to those arrangements changing when those with control for the decision-making form a view that that's what's appropriate. And one of the official solicitor's examples, which no doubt Miss Sutton will take the court to, shows exactly that. An individual whose care arrangements were authorised through the Court of Protection because they weren't in a care home or a hospital, and for year after year they were effectively rubber-stamped because everyone was happy with them, but one year there was a change, and suddenly there needed to be a court hearing, and the restrictions, the additional restrictions that had been brought in, were then taken away by the court. They were not authorised. And that's the sort of experience that the charities have of how these safeguards have in fact worked in practice. So turning to this question of valid consent, to go along with the proposal that's put forward, the court would have to do three things in my submission. First, accept that an inability to give decision-specific consent to one's care arrangements does not preclude giving valid consent to those very same care arrangements. That requires, secondly, the court to interpret valid...
I'm so sorry, would you mind just repeating that?
Yes, so you first need to accept an inability to give decision-specific consent to one's care arrangements does not preclude you giving valid consent to those very same care arrangements.
So is that the difference between the domestic concept of capacity and...
Exactly. So that takes the court on to the next step of the reasoning. That would mean that the court would have to interpret valid consent as meaning something other than having the ability to understand relevant information about your situation and use it to make a decision.
means something other than...
Something other than understanding relevant information about your situation and using it to make a decision. Because that's the test for capacity to consent in all of the domestic legal frameworks. You need to be able to understand, retain, use or weigh information in order to communicate a decision.
You've got to understand in a way different from the Attorney General's submission about the autonomous concept,
yes.
basically. I mean, there is a major difference between the two.
So when we get to the case law, I'm going to say that it's clearly an autonomous concept in the sense that it's a phrase that Strasbourg uses, valid consent, and they look at it in the context of the applications that come before them, which are legal systems nothing like ours, although a little bit like Scotland. But when you look at the substance of what they spell out valid consent to mean, you end up back with informed consent, which is what we have in our domestic framework. Yes. And that's in the cases that you haven't been taken to yet.
Your second point was understand and retain information.
Yes, so the full test is understand, retain, use or weigh, and if you can't do one of those things, you don't have capacity.
I'm sorry, understand, retain, and then
use or weigh.
Yes.
Use or weigh.
And the last factor is communicate a decision.
Yes, because among the elderly with dementia, retention can be a great problem. I recall with my own mother having the same conversation every 10 minutes.
Absolutely, and one of the, in the English legislation anyway, there's specific provision to reassure people that just because you can only retain it for a short period of time, don't assume that that means you don't have capacity. You've just got to be able to hold it in your mind long enough to make the decision. That works for kind of one-off decisions like do you want to buy this house or not. It doesn't work so well for do you wish to be cared for in this care home for the next 3 years.
So it's not just understand, there are these further
exactly.
tests.
Although in practice, usually why people are found to lack capacity is either that they simply can't understand the relevant information, they don't understand that they have care needs at all, and if they didn't receive care they would be in trouble, or they can understand it but they can't weigh it up in order to reach a decision about it.
Thank you. And there was a third point, I think.
Yes, and so the third point is, in my submission, that if the court was to head down that path and say that valid consent does mean something different, the court would have to explain, or at least be satisfied that it was possible to explain how the category of people who lack capacity to consent to their care arrangements can be separated into those who can give valid consent and those who can't. And the final sort of preliminary point is just to note that if the court does go down this path, it will apply wherever Article 5.1e in particular comes in. That includes psychiatric hospitals. You couldn't, in my submission, you couldn't interpret what Strasbourg has said as being that valid consent means one thing for people in psychiatric hospitals but something different for people in other settings. There's no hint in the authorities that the setting is relevant to the concept of what valid consent means.
I mean, yeah, and partly the force of that submission depends on what role valid consent is playing.
Yes.
Is it being treated as a complete defence,
yes,
or is it just treated as a factor which goes into be weighed amongst other factors? Because if it's the latter,
yes,
you know, the fact that you're in a psychiatric hospital, usually there will be lots of indicators
yes,
on a Ghazardi approach to show that you're actually deprived of liberty.
And what I'm going to say is that of course it's a complete defence, because the reason Strasbourg says valid consent, not just is there consent, is that there's consent in lots of these cases. In many of these authorities, if not all of them, the guardian has consented. That's the framework in these jurisdictions where guardianships are made. Someone is appointed a guardian, like Mr. Mihailov's. His wife was appointed as guardian 8 or 10 years before he started, but before the decisions were made at the final level in his domestic courts. She was appointed as guardian. She was consenting to all of this on his behalf. So the second limb can't just be is there consent, it has to be is there valid consent, and that's why the court then looks at the nature of the consent, who's giving it, under what circumstances, what were they informed about, do they have the ability to understand what's going on, and then only having gone through those steps does the court say, well, yes, that's valid consent, or no, it isn't. We say this is actually relatively simple, and that the Strasbourg case law says exactly what you'd expect it to say. And I'm just going to flag up the at page 2023, the Mental Health Act Code of Practice for England and Wales, which says at paragraph 24.35, by definition, a person who lacks capacity is unable to consent or refuse treatment, even if they cooperate with the treatment or actively seek it.
2023.
2023. And we say that sort of common sense understanding of what capacity and consent mean and their implications explain why at no point prior to Cheshire West, or indeed after it, has anyone actually tried to argue that someone simultaneously lacks capacity in domestic terms to consent to their care arrangements, but can nevertheless give valid consent to them.
Right. So, 2023
Yes.
seems to be consent to a particular treatment. So we seem to be in the medical context,
Yes.
where obviously
It is,
domestic
yes.
law capacity would be
Yes.
the governing
Yes,
concept.
but we say that this is just a common sense explanation of what everyone understands by consent. It means that, and capacity. If you don't have capacity to consent or refuse, then the fact of whether you're cooperating or not is neither here nor there.
Yes, but our whole discussion is
Yes.
about whether there
that's
is
right.
a separate
Absolutely.
autonomous concept.
Exactly, and I'm
not
finally
sure
going to
this
get
can
to the
help
case
us.
law. I'm finally going to get to the case law to show why I say that's where we end up once we've been to Strasbourg. So the court's already had to look at HL a number of times, so I'm hoping not to go back to it. But the facts of HL are important. Although he was agitated on the first day, and that's why he was taken to A&E, where he was given some sedating medication, at the point where it was decided whether to keep him in hospital, he was fully compliant. And so you can see that at page 4606 and 4607 in the quotes from the treating doctor. The other bit of HL, just to flag up, is that it was argued by the government in that case, paragraph 80 at 4263, that if HL was deprived of his liberty, then so would a lot of people be, including in their own private homes. It was known and accepted at the time that the logic of HL's case would apply more broadly and outside a psychiatric.
You can give me the page number. And
Yes, 4263. So we know from HL that although the stalk factors weren't being considered separately, the court proceeded on the basis that he was legally incapable of consenting to being confined in the hospital, and he was so confined and deprived of his liberty. Then the court was taken to stalk, where the court says, in the alternative, if the applicant wasn't capable of consenting because of treatment with strong medicines, then she could not be considered as having validly agreed to her stay in the clinic. That was page 4661. And the court says, indeed, a comparison of the facts with those in HL in the UK cannot but confirm this finding. Then you come to the one case which is said to derail the understanding that capacity and valid consent go alongside each other.
So sorry to interrupt you. Which was the
Yes.
paragraph number in Stalk?
Apologies, 76.
Thank you.
And then 77. So then you come to Mihailov's, which is the only case which is said to show us that valid consent means something rather different. And the key facts to which I would draw the court's attention in that case are that Mr. Mihailov's had his legal capacity removed through appointment of his wife as a guardian years before the issues in the case. And at that point, he had no mental illness. Page 4973, his central diagnosis was epilepsy or epileptic dementia. That is paragraph 8 of the judgment. His own evidence was that when he wasn't having an epileptic seizure, he was fully capable. That's paragraph 111 at 4995. And the court concluded that there was a lack of any objective medical evidence which would have justified his detention. And that's page 5004. at paragraph 148. So that is a long way from a person under one of the domestic frameworks who has been assessed at the relevant time that the decision is being made as lacking capacity to consent to their care arrangements. Then at page 5000, paragraph 134, where the court turns to the subjective element, the court reiterates the fact that the applicant lacked a jure legal capacity to decide matters for himself does not necessarily mean that he was de facto unable to understand his situation. Well, that's not a surprising finding, given that he was the subject of a blanket guardianship order made a number of years previously, and that there was no evidence, no contemporaneous evidence of his ability to make a decision. And that's why we say in our submissions that where you are looking at a regime where you can have a blanket removal of legal capacity, it may well make sense to say, is this person nevertheless giving valid consent? Because it may be that they do actually have the ability to make their own decision at that particular time. And so what the court's effectively doing is asking the sort of question that we would ask under our domestic frameworks. In respect of these care arrangements at this time, was the person able to understand what was happening and reach a decision about it? And if we see the next two cases I'm going to take the court to, in my submission, they make that even clearer. So the next case is M and Ukraine. And this is a decision from 2012. And again, it's in the context of psychiatric detention in hospital. So this is page 4831, paragraph 68, where the court says, identifies the dispute. The government maintained the applicant was admitted to the hospital on the basis of her own application, which was sufficient to show that the hospitalisation was voluntary, but she disagreed, claiming that she was compelled to sign the admission application. The court then repeats the familiar points from Stork and the critical point at the end of paragraph 69, that detention may violate Article 5 even when the person concerned has agreed to it. And then down to page 4833, starting at paragraph 75, the court says this: the court considers that medical practitioners are required to pay particular attention to the validity of decisions made by a person whose mental health is questionable. And at paragraph 76, they go to the international community's agreed principles about informed consent. Yes, in the context of psychiatric treatment, but that's because that's what the case is about. Those principles of informed consent are internationally accepted principles for medical treatment generally, not just psychiatric treatment. And in all of our domestic frameworks, that concept of informed consent is exactly how this works. That's why there's a functional capacity test on a decision-specific basis. And so paragraph 77, the court takes the view that a person's consent to admission to a mental health facility for inpatient treatment can be regarded as valid for the purposes of the Convention only where there's sufficient and reliable evidence suggesting that the person's mental ability to consent and comprehend the questions thereof has been objectively established in the course of a fair and proper procedure, and that all the necessary information concerning placement and intended treatment has been adequately provided to him. And we say that's pretty close to you've carried out a decision and time-specific mental capacity assessment as you would have to under the domestic frameworks.
That, just in terms of formulation, that seems very much tied to consent to admission to a mental health facility, in other words, being taken into a psychiatric hospital. Yes,
it does, but it is then applied by the court in the case of Stankov at page 5185. Sorry, it starts at 5185, but the actual passage that I'm going to rely on is 5207. Paragraph 90. Court's not convinced the interested party validly consented to the placement or accepted it later, and this is a social care placement, recalls what it's previously said in M in Ukraine, and then says, towards the end of that, paragraph 90. And then the sort of final third of that
terribly
paragraph.
sorry than the page number.
I'm sorry, 5207. So the court goes back to what it's said in M in Ukraine and then says the court considers that this principle is also applicable when it comes to obtaining consent for the placement in a social care home of a person whose legal capacity is impaired due to their mental health, as in the present case.
But isn't there a relationship when you're trying to ascertain whether somebody is consenting to something? The likelihood of them consenting to it turns on how pleasant or unpleasant it is. If you've got someone who's locked 23 hours a day in a horrible cell with no daylight, the likelihood of them actually consenting to that is minimal, whatever they say. Whereas if they're in their own home and going out and about pretty much as they would want to, it's more likely that their consent is a genuine consent, isn't it? I mean, isn't always the question of how likely it is that somebody has or did have that frame of mind at any particular moment turns on a common sense assessment of how likely it was.
So we say that's not what the court is saying. The court is saying as a first step, give the person the information, carry out a proper process and establish whether or not they did give consent. But the court doesn't stop there in Strasbourg. They then go on to say, even if you have done all of that, we might say that it's still not valid consent for some other reason. But this is the first stage, which is what is the content of the consent that we're talking about for the purposes of valid consent. And the content is that capacity to consent and to understand the consequences of that act have been established in a fair and appropriate procedure and all necessary information has been adequately provided. So go through this process of eliciting a consent from the person, check that they understand, and so on. But there is then a further question. They might do all of that and consent, and the court may still say it's not valid consent. And we see an example of that in N in Romania. That, again, is a psychiatric detention case where there came a point when the authorities said, well, actually, you don't need to be here anymore. But it then took a long time for anyone to find an appropriate social care placement for the person. And so the court, but during that period, the individual, through his legal representative, said, that's fine, I will stay here while you find me somewhere because I don't want to be homeless, I don't want to be on the streets. And the individual gave that agreement, and it was confirmed in writing through their legal representative. And even that wasn't good enough to be valid consent for the court in that case. At page 5435, paragraph 165, the court said that even though the applicant agreed to remain confined until the welfare services found a solution appropriate to his situation, which agreement was shored up by the concurring letter written by his legal representative. So there was no doubt about there having been a proper process and him having had things explained to him because his own lawyer had confirmed it. He ought to be granted adequate safeguards for his protection, which should in particular lead to his release without unjustified delay, and there was still a breach of Article 5. And that comes back to my Lady Rose's question.
So what then do they do with him? So then he has to go out and sleep on the street then until they find him.
I think
it's a bit of a bizarre decision.
Well, I think what happens in practice in these cases, and they occur in this in the Court of Protection as well, is that there's an ongoing breach of Article 5, which may sound in damages for the person while the relevant body gets its act together and finds an appropriate placement. But of course,
is that a satisfactory state?
Well, at that point, one gets into the balance between Article 5 and Article 2 and so on, and so that's where one eventually ends up. But that's an illustration of the court separating out in my submission the process question of eliciting consent, informed consent, then wanting to still check validity, and it comes to the point that was made, I think, yesterday, which is, well, this need for safeguards, is that an Article 5.1 point or an Article 5.4 point? You can see from this it's absolutely an Article 5.1 point, because what they're saying is no matter that you've actually given informed consent to these arrangements, because you're the sort of person that needs adequate safeguards for your protection, we're still going to say it's a breach of Article 5. And that, although this judgment was made after Cheshire West, in my submission that ties in very clearly with what the majority in Cheshire West were saying about the sort of point of principle, which is this is a very vulnerable group of people, and we need to be thinking in those terms about erring on the side of caution. That's what the European Court are doing here. They're erring on the side of caution, saying even though you've said yes and your lawyers signed the letter, we're still going to say you are the kind of person that needs these safeguards.
But it might be said on the facts of this case that the actual consent to being detained in this way was undermined by the fact that there was no serious option offered by the state as an alternative to that. So it
might be said, but it's not what's said by Strasbourg. Yes.
Sorry? Right.
And so that's why we say that this suggestion that in Cheshire West the court went beyond Strasbourg, or that in some way the courts so far have failed to take account of the views of the individual, or that the submission that what Mihailov's is saying is that wishes and feelings are what's relevant for valid consent. We say all of that is wrong. That's not what Mihailov says. So what's clear from these cases is that Strasbourg is not that interested in the views of the person unless they can satisfy themselves that that person's been properly informed about the actual question at the time it falls to be made. They're willing to ask those questions and look behind a blanket removal of legal capacity. But that's not the same as saying that what Strasbourg means by valid consent is something different to what we understand by consent, capacitous consent. And then if we think about those Strasbourg cases in the context of Mig, who seems to be being set up as the person who might fall into this hypothetical category, this is not language that the charities would endorse, but she's described as having the cognitive abilities of a 2-year-old. Compare and contrast with N and Romania and M and Ukraine, where the court is talking about the need to provide information to someone to check their understanding of it. They're not talking about whether they appear to be content. And so we say that in fact, it's possible for the court to be very confident indeed about what Strasbourg would say about valid consent, but in the opposite direction to the way the Attorney General says. And we say that the court can be fully confident that a time and decision-specific assessment that someone lacks capacity to consent to their care arrangements would be seen by Strasbourg as meaning that there was no valid consent. And we say further that the suggestion in reliance primarily on cases about Article 3, that somehow that conclusion can be undermined because of bringing in this element of necessary suffering and humiliation doesn't work. This line of case law is clear. There is no suggestion in HL and the UK that suffering and humiliation were any part of the court's reasoning in relation to Article 5. And that line of case law just doesn't assist when the case law on this very specific question is actually clear. And so to that extent, where Baroness Hale says in Cheshire West that she found the Mihailov's case difficult, In my submission, it isn't difficult, and particularly now that it's been elucidated by the application of in Ukraine in the social care context and the reinforcement of that informed consent process as being a critical part of there being valid consent. In the last 5 minutes today, I'm just going to very briefly run through why we say that the court could deal with these issues in relation to valid consent without going back to Cheshire West. The subjective limb, as has already been pointed out, wasn't an issue. This court in Re D has already explained that what Cheshire West did was to clarify the objective elements of a deprivation of liberty. And the Secretary of State says, well, it's difficult to reconcile Mihailov's with lack of objection not being relevant to stalk limb A, and so that's why you have to look at it all together. But we say that's wrong. The question under limb B is there understanding and acceptance of the concrete situation? We know from HL that the concrete situation can satisfy limb A even if there's no objection. So an objection is not a necessary condition for limb A, even though it may well be relevant and clearly is taken into account in many cases when looking at limb A. It's theoretically possible that incapacitous valid consent is a concept that makes sense. And that proposition that the Attorney General makes is not dependent on anything to do with limb A. If objection was a necessary condition in relation to limb A, things might be different, but we know it isn't.
I mean, if objection was a necessary element of confinement.
Exactly, yes. I think that's probably a good place to stop, unless there are any questions at this juncture.
Yes, certainly. We'll adjourn then for the day and resume at 10:30 tomorrow morning.